There are actually a whole lot of reasons you might need to modify your parenting plan or your custody arrangement, ranging from, adjustments that just put on paper what's been happening for a long time, to clarify an order, or to do a total revamp if your life situation or children's life situation changes such that the current order just isn't applicable anymore. I most often see this necessary when parents that got divorced when children are small and the children have aged up. In particular, I recently talked to someone who had a parenting plan that was put in place by a court in another state, and the parents had just worked everything out for a really long time. But recently, their daughter had run into some mental health issues, and the court order didn't provide for mom to have access to any information or even to make any decision making on that. The court order actually was just silent, and it became an issue. So that was a time when it was actually imperative that the court step in, modify the plan so that the medical providers would give mom access to information that she needed to care for her child. Well, filing for a modification in general is a matter of filing a document with the court, letting it know that a modification is needed. Some court orders require that you do some preliminary things like talk with the other side. That's always a good idea anyway. And you have to make sure that when you're, filing the documents, that you're, complying with any statutory requirements to make sure that your case gets timely heard. I always recommend that you at least do a consultation, and many attorneys will, do a paid consultation to go over the order that needs to be modified and at least get some direction on, whether to do it, how to do it, and, even if you want to proceed to do that on your own. And a simple modification oftentimes can be handled on your own. So your burden of proof, meaning what you have to show the court ultimately to prevail if you had, go into trial to get the change, is going to depend based on, what's going on in your case. But in general, the courts are going to look at changes to a parenting plan, be that, just to clarify something, or, really significantly revamp on a best interest standard. There are some times when endangerment has to be shown, or there's some other, technical pleading rules that are going to apply. Again, that's why I think it's always best to check in with an attorney about your situation and get some, expert advice from someone who litigates these types of changes on a regular basis. You have to be careful about temporary changes because if you agree to change or, kind of go off script from the current parenting plan, the court could find that you agreed to a permanent change, even when you meant it to be temporary. In fact, some states, a temporary change is a permanent change, and it can become what is known as the de facto parenting plan, even though what's in writing, the de jure parenting plan, conflicts with it. So if you're considering a change to your parenting plan, a modification of custody, be that parenting time or decision making, give us a call. We'll be happy to sit down with you, evaluate your case, and set you off down the right path.